Hello, my name is Olivia. Today I will be presenting the COVID-19 Workplace Safety Training, covering state health and labor requirements. As more people get vaccinated and employers begin to consider changes in working conditions, it remains essential to maintain the following safety practices. Employers have the legal responsibility to provide safe workplaces. California now has specific regulations called the COVID-19 Prevention Emergency Temporary Standards that describe specifically what employers are required to do to protect workers. Key responsibilities for employers are to identify hazards at the specific worksite that may expose workers to COVID-19 and to implement measures to control and reduce workers' exposure. Additionally, employees must screen employees for symptoms or ask employees to do a daily symptom check before coming to work. Respond immediately when they become aware that a worker has symptoms or might have COVID-19 by evaluating the potential exposure to other workers and by notifying workers of their potential exposure. Health departments recommend anyone with any symptom of COVID-19 to self-isolate, not come to work, and to get a COVID-19 test. Remember that even if no one has symptoms of COVID-19, these prevention measures must be followed at all times because you can have and spread the virus when not experiencing any symptoms. Safety measures employers must take include implementing procedures for workers to be physically distanced, at least 6 feet apart as much as possible. Maximize the quantity of air outside the workplace to extend feasible ventilation. Provide face coverings and ensure they are used properly. Provide the time and supplies for increased hand washing. Provide the time and supplies for cleaning and disinfection of commonly touched surfaces and objects. And lastly, notify workers of potential exposures. Employers must modify the workplace and implement procedures so workers can be at least 6 feet apart from each other and the public as much as possible when at work. At work sites, both mechanical and natural ventilation must be included. The amount of outdoor air in the workplace must be maximized. Depending on the work site, it may also be possible to open windows and doors to improve ventilation. Face coverings help protect the people around you by reducing the spread of potentially infectious particles. Employers are required to provide face coverings for workers free of cost, or the employer should reimburse workers for the reasonable cost of obtaining them. They're also required to make sure workers use face coverings correctly. Employers are required to develop a written COVID-19 prevention program that is specific to the work site. A key component of this plan is the identification, evaluation, and correction of COVID-19 hazards. Workers and their representatives have the right to actively participate in identifying hazards and solutions for their employer's COVID-19 prevention program. Another requirement of the COVID-19 Prevention Emergency Temporary Standards is about training and communication with workers. Employers have to provide effective training on COVID-19 transmission, symptoms, and prevention, on-leave benefits that help workers stay home due to the potential exposure, illness, and on their policies and procedures to protect workers. In California, all workplace safety and health training and communication for workers must be provided in a manner that they understand. If workers test positive or become sick with COVID-19, the COVID-19 positive worker must be excluded from the workplace for 10 days, and employers must evaluate who else may have been exposed. Any workers who are possibly exposed must be notified in writing immediately or within 1 business day. Exposed workers must also be excluded from the workplace for 10 days. At this time, employers must give potentially exposed workers access to free COVID-19 testing and inform them of their benefits, including paid leave, to financially help them stay home and recover. Employers must also ensure workers do not incur a cost for testing, so it must be done on time. Employers must investigate whether any workplace conditions contributed to the risk of COVID-19 exposure, and if additional safety measures might be needed to reduce those hazards. If 3 or more workers test positive or are ill with COVID-19 within a 14-day period, it is considered an outbreak by Cal OSHA, and the employer has more responsibilities, including providing COVID-19 testing and notifying the local health department. Employers are required to maintain accurate records of workplace injuries and illnesses, so they will need to ask about the COVID-19 illness to obtain medical information that will also be provided to the local health department. The resources that follow are available for workers regardless of their immigration status. California law requires employers to provide paid sick leave. At a minimum, employees earn 1 hour of sick leave for every 30 hours of work. An employer may limit the use in a 12-month period to 3 days or 24 hours. To qualify to use this paid leave, the worker must have worked for 90 days with the same employer and have worked at least 30 days in the year. Workers can use paid sick leave to get tested for COVID-19, if they or a family member are sick with COVID-19, to care for a family member with COVID-19, or if they or a family member have been required to quarantine because of a COVID-19 exposure. State Disability Insurance, or SDI, is a program that employees pay into, which pays benefits if the worker is unable to work because of a non-related work injury or illness, such as COVID-19. The benefit can last up to 52 weeks. Depending on how much a person earns, SDI will cover 60 to 70% of wages that they would normally earn based on their earnings history. The minimum benefit is $50 per week, and the maximum is $1,357 per week. To qualify for SDI, a healthcare provider or a local county health official must complete a certification showing that the worker cannot work because of COVID-19 exposure or because of an illness or injury. Paid family leave allows workers to receive 60 to 70% of their regular wages if they need to stay home to care for a close family member who is ill or quarantined because of COVID-19. A close family member means someone who is a child, parent, or parent-in-law, grandparent or grandchild, sibling, spouse, or registered domestic partner. Another benefit amount is the same as SDI. The maximum period for benefits is 8 weeks. EDD also administers the paid family leave program, and the application requirements are similar to SDI. Just like SDI, the worker will need to submit a medical certification for the family member they will be caring for while on leave. All employers are required to have a workers' compensation insurance policy, which provides benefits to workers who are injured or sick because of work, including COVID-19. Workers' compensation benefits are designed to provide workers with the medical treatment they need to recover from a work-related injury or illness, partially replace the wages lost while recovering, and help them return to work. If a worker thinks they got infected with COVID-19 at work, they have the right to workers' compensation. Workers should notify their employer right away when they think the illness is work-related and file a workers' compensation claim. Workers' compensation benefits protect all workers, regardless of immigration status. A new law clarifies that any worker who thinks they got infected during an outbreak is also presumed to be eligible for workers' compensation benefits. Even if there's no outbreak, a COVID-19 case can still be work-related. If the claim is disputed, the worker would need to present evidence to show that they were likely infected at work or through a work-related activity. To file a workers' compensation claim, workers should follow these steps. report the COVID-19 illness to the employer, and the employer must give them a claim form within 1 working day. And the employer may have up to 90 days to accept or deny the claim. If the employer denies the claim, the employee should file a case with the Workers' Compensation Appeals Board to dispute the denial. Generally, workers cannot get both workers' compensation benefits and state disability insurance benefits at the same time, but it is common to file a workers' compensation claim and then request state disability insurance if the claim is investigated or after it's denied. Even if workers don't have access to any more paid medical leave, there are laws that protect the worker's job while they stay home to recover from an illness or to care for a family member who is ill with COVID-19 or another serious medical condition. In general, the California Family Rights Act, or CFRA, provides for up to 12 weeks per year of leave from work. This right applies to workers who work from employers with at least 5 employees. To be eligible for this leave, the worker must have worked for the employer for more than 12 months and for at least 1,250 hours during the 12 months before the leave. In addition, a worker who is disabled, whether or not connected to COVID-19 illness, may be entitled to leave as a reasonable accommodation. An employee who qualifies for CFRA leave may get paid during their leave if they use paid time off, or if they apply to the EDD and qualify for SDI or paid family leave. Fear of retaliation can be a major reason why workers don't take action and instead put up with unsafe working conditions and labor violations. Retaliation is strictly prohibited in California, and the laws provide strong penalties to stop employers from punishing and threatening their workers who exercise their rights. Workers are protected from retaliation when they raise concerns or report hazards, illnesses, or injuries, when they organize or take action together, request or take paid leave, file a workers' compensation claim, or file a complaint with a government agency. In addition, workers can refuse to work in unsafe conditions. If employers are not providing what is required or necessary to protect workers from COVID-19, there are different ways that workers can address these problems. Often, the most direct way to resolve workplace problems is for workers to communicate directly with their supervisor, manager, or employer. Before going to have this conversation, it is useful to do a little planning. For example, workers can do the following. Think about what the risks or problems are and what they want to change. Document the problem as much as possible. This can include writing down notes of what happened at specific times, who is affected, where it happens, and possibly taking pictures. Talk to coworkers, get information about their rights. Find out who may have authority to make decisions or changes. Is it a manager, HR? Anticipate what employers may say to oppose or dismiss workers' requests, and be prepared to remain calm and offer other options. Additional sources where workers can seek support include unions, worker centers, legal organizations, community-based organizations, and government information lines and websites. Workers may be in situations where their health and safety are at risk, and they want to get help from an agency. Perhaps they fear speaking to their employer. They already have tried, but nothing changed, or there's a really serious risk that requires quick action. Workers have the right to report a problem to Cal OSHA. Cal OSHA maintains your complaint information as confidential, including your name, contact information, and the nature of your exact complaint. Workers can file a complaint anonymously by not giving their name, but when they provide their name and contact information, Cal OSHA has more tools to follow up and investigate. Community and worker organizations, as well as unions, can help workers put together a complaint and can also file a complaint on behalf of workers. The worker can also help assess if there are other workers who could be witnesses and help the workers gather information that would be useful to Cal OSHA. If a worker files a complaint, Cal OSHA will take the following steps. Cal OSHA investigators will go to the job site if they believe their employer is violating health, worker, and safety standards, or if workers are in danger of getting sick from COVID-19. They will conduct an investigation in a way that does not reveal the identity of the complainant. Cal OSHA will ask the employer and workers questions to learn more about the hazards. The worker has the right to speak with the investigator in private, get the investigator's phone number, and if they prefer to speak to you when you're not at work. If the employer is found to have violated a standard, Cal OSHA will issue a citation with a monetary penalty to the employer. The employer must correct the problem no later than the indicated date. Thank you for listening.